Okay. All right, we are now live streaming, and we may have some feedback. We may have to deal with some issues there. We'll see. But we're all right. Can you give me something with the style of the case? So I can, okay, we are having a feedback. Let me go back to the. I think if I mute my live streaming, it won't be feeding back. Okay, do you have something with the style of the case so I can get us under oath and start it? Mr. Laskowski?
Yes, Your Honor.
Your proposed order or the decree, or well, actually the proposed order will be better because it'll have everything in a AG
Right.
form.
I can provide you the cause number if you'd like, Your Honor.
The cause number is 18 FD.
Well, I have that on the docket sheet. What I don't have, the reason I like it is I don't have the names of the children that are in the interest of it. Makes it a little.
In the interest of Adam Bradley Brown, a child.
Okay. We can take it from there then. That's all I need. Let me go ahead and start the record. Okay, we're now on the record on cause number 15FD. Oops, wrong case. This is Brown. We're now on the record on cause number 18FD1763 in the interest of, is it Adam David Brown?
Adam Bradley Brown.
Adam Bradley Brown. And you are Samuel Addison Brown?
Yes, Your Honor.
And also I have present Miss Dawn Michelle Brown. Are you present?
Yes, Your Honor.
Okay. Now, for the record, I'm going to tell you to raise your right hands. Do each of you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could you please ask Ms. Brown to keep her video on?
Ms. Brown, unless you're having streaming problems, it is better for us to keep your video on. So do so if you can. And I didn't hear your response since I am making a record. What is your response to swearing to tell the truth, the whole truth, nothing but the truth?
I do.
All right, we're under oath and on the record. And Ms. Laskowski, I guess this is the state's case, so you may proceed.
Yes, Your Honor. We're here on a petition for confirmation of a non-agreed child support review order. The hearing was requested on I believe July 6th, 2022. I've shared, actually I'll share. So on my screen, okay. State calls Ms. Brown. Ms. Brown, do you have an order for Mr. Brown to pay you child support?
Yes.
All right. At this time, the state asks the court to take judicial notice of what's been, well, I'll share it as an exhibit. What's been marked for evidence for identification purposes as State's Exhibit 1, the agreed final decree of divorce signed by the court on January 8th, 2019.
Okay, I have it, but it's not, like I said, it needs to be downloaded, so I will have it in my record of the case.
I'm sending it to you right now, Your Honor.
Okay.
I emailed both of them. I emailed both of you.
Okay.
Okay, well, that's fine. I will download it from my email.
All right. Ms. Brown,
Yes.
at the time of the divorce, how much was Mr. Brown ordered to pay you in child support?
$9.22 a month.
All right. Since the time of the order of the divorce decree, how often has Mr. Brown been visiting the child?
He gets him his period of possession. Typically, for the past 3 years, I would keep him while he was at work, like 6 a.m. to 6 p.m. Except for 1 year or one school semester, he had his mom keep him. But the last year or two, I kept him.
Since the time of the divorce, were you and Mr. Brown still doing the week-to-week possession and access schedule as outlined in the divorce decree?
Yes, the alternating week. Yes.
Where was Mr. Brown working at the time of the divorce?
Same place.
Do you know if Mr. Brown has had any pay raises since the time of the divorce?
I believe he's said 1 or 2. He also did not prove his income at the time of the divorce decree.
Objection, Your Honor, non-responsive. There's not a question.
And try to just answer the questions that have been presented to you, Ms. Brown. You'll get an opportunity if there's some other evidence you want to present in terms of testimony. But for right now, just answer the questions.
Yes, Your Honor.
Proceed, Ms. Laskowski.
No further questions for this witness at this time, Your Honor.
Your witness, counsel.
Now, ma'am, in the final decree of divorce, you and Mr. Brown agreed that he would pay you $1,000 per month. Is that correct?
Yes.
And that $1,000 per month was due to the fact that you both had completely equal access to your child. Is that right? Well, ma'am, do you agree that the $1,000 per month was not based on guideline child support?
I was not aware of this.
Now, ma'am, there's nothing in this order that makes you have any more rights than Mr. Brown. Is that correct?
I'm not sure I can answer that.
Okay, well, if we went through this order, every single one of these rights and duties, you guys have the right, subject to the agreement of the other parent conservator, and that if you can't agree, you have to follow the recommendations of particular people, correct?
Correct.
That you have no exclusive rights and no rights that he does not have, correct?
I believe you are correct.
And you are not a person who has the right to designate the primary residence of the child. The child's domicile is restricted to a particular county with no one having the right to designate that domicile, correct?
I am not sure. I believe that being the primary custodian that I did.
Well, ma'am, you're not the primary custodian. What makes you think you're the primary custodian?
I would like to review the order.
Well, what part would you like to review? You do not have any rights that Mr. Brown doesn't have under these orders. There's not a single right that you have that he doesn't have an equal right. Do you agree with that?
Mhm.
I thought I was the primary custodian.
There's nothing in this order that makes you the primary custodian. You do not have the exclusive right to designate the school. Y'all agreed to what school your child would attend, and that's Clear Creek ISD. Is that correct?
I believe so. I just know through OAG through all their
Objection.
paperwork
You're
and
staying
everything.
non-responsive.
Overruled. I think she can respond to what she believed. You kind of left her pretty broad as to why she believes she's the primary concern. Go ahead and answer that question. What makes you think that you are the primary conservator?
I should have paperwork somewhere, or OAG has sent me things that say that he's the non-custodial parent and I am the custodial parent.
Well, what I have in the evidence is the divorce decree. And unless you can point out a place in that divorce decree where the order orders you to have it, then anything that you might have been told by other attorneys, the AG or other attorneys, is not evidence in this case. Okay.
Okay.
Continue with your question.
So ma'am, in this final decree of divorce for education rights, you guys have the right, subject to the agreement of the other parent conservator, to make decisions regarding your child's education, and that you agreed your child would attend Clear Creek ISD unless otherwise agreed in writing. Is that correct?
Yes.
And you both agreed that your child's domicile would be restricted to Galveston County and contiguous counties, with no one having the primary right to designate the domicile within Galveston and contiguous. Is that correct?
Yes.
And all of these rights and duties, with the exception of the independent rights to manage the child's estate, are subject to the agreement of the other party and by agreement only, correct?
Yes.
And possession and access is exactly 50-50, week on, week off, from Friday at 6 to Friday at 6 the following week. Is that right?
Yes.
Now, you testified that for the past 3 years, you've been keeping your child from 6 a.m. to 6 p.m.
When he drops him off so he can go to work.
Okay. Now, your child attends school, doesn't he?
Yes.
How old is your child?
7.
And your child was in pre-K 3, pre-K 4, kindergarten, and first grade. Is that since the date of this order? Is that correct?
Correct. And pre-K 3 and pre-K 4 was half days.
Okay. And when he was in
I would be
pre-K,
available to pick up and drop off.
and when he was in pre-K 3 and pre-K 4, Mr. Brown's mother was the person who was picking up and dropping off, correct?
No.
And this past year, when he was in first grade, and Mr. Brown had conversation with you about needing to put his child in before or after school care. Is that correct?
We discussed that, but we decided that I would keep him.
You asked if you could have him before school and after school instead of him being in an alternative care, correct?
I stated that I can take care of him instead of that.
Okay. And so now, based on y'all's agreement and your election, Mr. Brown drops him off in the morning on his weeks, drops him off in the morning, and you take him to school. He feeds him before he brings him, correct?
Not all the time. Maybe like a Friday.
Okay, so
When
you're
it gets to
testifying, your testimony is he does not feed him breakfast before he drops him at your house?
I mean, he wakes up and puts him in the car to come to me.
Okay. And then he comes to your house after school based on your election, and Mr. Brown picks him up on the way home from work. Is that correct?
Yes.
And aside from that, you agree that he's exercised his week on, week off periods of possession since the date of this order, correct?
To an extent.
Okay. Now, at the time of this order, isn't it true that you did a calculation of his income and the fact that he was carrying health insurance as opposed to your income to come up with a modified child support amount of $1,000 per month?
OAG had told me my income is not
You're-
relevant, and
It's a hearsay, and I'm
Yeah, I was gonna just sua sponte speak to that. Please don't say what other people said. Ma'am, you.
I was just saying that I did not factor my income. No.
Okay, that's ask and answer.
Now, ma'am, I'm asking about the time of divorce, and you were represented by an attorney, Lacey Richmond, at that time, is that correct?
Yes.
You weren't discussing with the Office of the Attorney General what child support amount you were going to come up with when you guys were in an agreement, in a mediation with David Solinsky to come to this final agreement, correct?
No, we discussed 20% as
So
being a standard.
now okay, so you are not aware that you agreed to less than guideline support at the time of this final decree based on Mr. Brown having 50-50 access. Is that your testimony?
My testimony, I suppose, is that he did not even prove his income to base anything off of that.
Now, ma'am, at the time of this order in 2018, do you know where Mr. Brown was residing? What city?
Santa Fe.
And do you know where he's residing now? What city?
I suppose Santa Fe.
Okay, and
I
what
don't
city were
believe he
you
has a house in his name anymore.
and what city were you residing in at the time of divorce?
Lake City.
And where are you residing now?
Lake City.
Where was Mr. Brown working at the time of divorce?
Same place.
Precision Flange Machining? Is that
Yes,
correct? And he's working at the same place now?
I believe so.
And do you know, where were you working at the time of divorce?
I was a homemaker.
So you were unemployed at that time?
I believe so, taking care of my son.
Okay. And that, where are you working now?
I'm working at Naughty Mike's restaurant,
How long have you worked there?
about 2 weeks.
And are you a bartender at that restaurant?
Server.
You're a server? Are you training to be a bartender?
Somewhat. That's the plan, but
How much are you earning per week?
I don't have
Hold
anything
on,
yet.
counsel. Hold on, counsel.
Yes, Your Honor.
When was this action filed?
The petition to enter this order in July.
Was that more than 2 weeks ago?
I don't actually have a file stamp, so I'm not sure exactly when. I think it was filed July 22nd.
Okay.
The
Well, I have-
petition, the petition for confirmation of non-agreed child support review order was filed July 7th, Your Honor.
Well, my question is, we're looking at changed circumstances is obviously the issue, and I don't know what she's made in a job that she just got 2 weeks ago is relevant. But you go ahead and continue that line of questioning, counsel, if you want to get that in.
Okay. Have you received any sort of income so far from this job?
No.
Okay. Do you know do you know what hourly rate you're guaranteed to make?
Standard server amount. Just the base rate for that, probably $2. an
Okay.
hour.
We know you make at least minimum wage because that's a law, but have they offered you more than that per hour? What is your hourly rate that they're paying you?
As far as I know, it's about $2 an hour.
Counsel,
Yes, Your Honor.
I'm going to give you the benefit. I'm married to a tax accountant. The IRS presumes minimum wage on
I
a
understand.
server on tips. But yes, restaurants generally pay $2.13 an hour for servers, assuming they'll get tips that'll reach them above the minimum wage. And at this point, I don't think there's any way to know exactly what she's making other than that presumption.
Okay, Your Honor, I'll move on from that. Your child was attending Ross Elementary School at the time of this divorce?
Yes.
Is he still attending Ross Elementary School?
Yes.
And your possession and access in this divorce was 50-50, correct?
In the decree, yes.
And Mr. Brown and you have been splitting extracurricular activities 50-50, is that correct?
For the most part, I guess.
I'll pass the witness, Your Honor.
Redirect, Ms. Laskowski.
No questions, Your Honor.
Okay. Ms. Brown, since you're not represented by counsel in this, is there anything else that you want to say that hasn't been covered by Ms. Parker's questions or Ms. Laskowski's questions? Anything else you want to put in before we move on?
I guess as far as material or substantial change, I mean, the whole proof of income thing on his part, and
Okay, well,
he
that's
does not have a house in his
I'll
name
give you a
anymore.
chance to argue your position before I make a ruling. I was just talking about any other evidence that you wanted to say. Yeah, I'll give you the opportunity to give me your perspective before I make my ruling. Ms. Laskowski, do you have another witness, or are we going to turn it over to Ms. Parker?
State calls Mr. Brown.
Okay,
All right. Mr. Brown. Where were you employed at the time of the divorce?
Precision Flange and Machine Incorporated.
How much did you make for them at that time? Or how much did you earn at that job then?
As the quality manager, I'm a salary employee, making $115,000 a year.
Is that your current income?
No,
So you are making $115,000 at the time of the divorce in
Yes, ma'am.
2019? How much are you making now?
I believe I received a small cost of living increase in April of this year. And so it's going to be $120,000.
Do you have any other source of income aside from your employment at Precision?
Yes, ma'am.
What income is that?
I have a property that I own, and I receive rental income.
How much rental income do you receive per month?
It's not consistent. The most that I could receive per month would be $900.
How long have you had that rental income?
Just like I said, it's sporadic. So let's say maybe a total of 4 months in the last year.
Did you have that rental income at the time of your divorce? Did you own that rental property at that point?
No, ma'am. No, ma'am.
What kind of maintenance costs for you as the owner of that rental property do you have?
I have a lot of maintenance upkeep. It's a 5-acre property. So I have to mow it, maintain the trailer and the mower to use it. I have to maintain a well system and a septic system. And I have to maintain tree trimming, power lines, access and entry. And as an example, I just recently had to put down crushed gravel, concrete to fill in potholes on the road and that kind of thing.
What are the estimated monthly maintenance costs associated with that?
Only maintenance costs, correct?
Yes, monthly maintenance costs.
It's hard to estimate because there's a lot of factors, but it's easily over $100, so several $100s a month.
You have any kind of mortgage on that rental property?
Yes, ma'am.
How much is that monthly mortgage?
1672.
All right, that $900 rental income, was that your net monthly rental income that you gave?
Yes, ma'am. I believe that would be net.
Okay, so that's after you've paid the mortgage and any maintenance, you have a $900 profit on that rental property?
Electricity, it depends. Occasionally bills are higher, things like that. So it's variable. I wouldn't say that that's consistent, no ma'am. Because it depends. I have 2 RV sites and one may be rented, one may not. And there was about a 6 to 8 month period in the last year that nobody was renting from me. So I don't know how to tell you exactly.
Pass the witness, Your Honor.
Ms. Parker, the witness.
Just to be clear, as far as this rental income you have, it's not your testimony that you make $900 a month on this rental property, correct?
Correct.
Okay, because I don't think that was very clear in the way that you answered. You have a mortgage of $1672 per month, correct?
Yes, ma'am.
And in addition to that, you have maintenance and upkeep and all of these other well and septic, tree trimming, power lines, access and entry, and all of those other things that are in addition to your mortgage, correct?
Yes, that's correct, including also annual taxes.
So if you take all of the expenses that you have on this property, do you receive money from renting this property that exceeds the amount of expenses that you pay on the property?
No, ma'am.
Okay, so you're operating at a loss on that property, is that correct?
That's correct.
And as far as your income, when you agreed in this final decree of divorce to $1,000 per month that you would pay in child support, was that based on your earnings at that time?
Yes, ma'am.
Did you take into consideration an offset based on minimum wage child support for Ms. Brown?
Yes, ma'am.
And did you also take into consideration the fact that you would be paying 100% of the health insurance cost versus having her reimburse you?
Yes, ma'am.
And when you took those calculations, all offsetting each other, you came up with $1,000 a month?
Yes, ma'am, that's correct.
Now, I went through some of these things that were happening at the time of divorce and that are happening now. Let me just kind of reiterate some of them with you. You were working at the same employer that you're working at now, is that correct?
Yes, ma'am.
And you're basically making the same income versus the minimal increase that you've received for cost of living increase.
That's correct.
And have your costs of living increased?
Yes, ma'am.
And what was your position at this employer at the time of the order?
Quality manager.
What is your position now?
Quality manager.
And Ms. Brown testified that she was not working at the time of the divorce, so her income was based on a minimum wage at that time. Is that correct?
Yes, ma'am.
And we're basing her income on minimum wage today, correct?
Correct.
And let's talk about the possession and access and whether there's been a change. At the time of this order, when you guys had week on, week off, were you exercising your possession for week on, week off?
Yes, ma'am.
Was your child in school at that time?
Yes, ma'am.
Who was taking him to school in the morning?
I was.
And were you able to do that with your work?
Yes, ma'am.
How did you do that?
The owner of my company was a single father who had custody of a young daughter. He's been very supportive of my situation and trying to help me in any way he can. So he allowed me to come in. My working hours are 7 to 5. He allowed me to come in at 8:30 so that I could take my son to school by 8.
Were you picking your son up from school?
I was having my son picked up from school.
And who was picking your son up from school?
My mother.
And how long did this arrangement go on where you were dropping him off and your mother was picking him up?
While he was in school doing half days.
And so that was the remainder of his school year from the 2018-2019 school year?
Yes, ma'am. Correct.
Also doing half days the following year when he was in pre-K 4?
Yes, ma'am. I believe that's correct as well.
And were you doing that same arrangement at that time?
Correct.
Now, when did your son start full days?
Kindergarten.
And what grade will he go into next year?
He'll be in 2nd grade next year.
So we're talking about the kindergarten and the 1st grade school year, correct?
Yes, ma'am. Correct.
And during those, did you continue to go in late?
No, ma'am.
Did you and Miss Brown have a conversation about some alternatives for your son in the morning?
Yes, we did.
And what did the two of you agree to?
We agreed that I would drop him off in the morning before school, and I would pick him up on my way home after school, after work, excuse me.
And she elected to do that versus the alternative of you putting him in a before and after school care.
Yes, ma'am. That's correct.
Do you feed your son breakfast in the mornings?
Yes, ma'am. Generally a snack, or I'll pick him up some donuts or something like that.
And then you drop him off at her house. Is that correct?
That's correct.
And do you go straight from work to pick him up after work?
Yes, ma'am.
Do you feed him dinner?
Yes, ma'am.
Now, as far as the other expenses that your son has, extracurricular activities, do you guys share those expenses?
That's correct.
And how do you split them?
50-50. Anytime the receipt, is provided, or we know what the amount is and agree to it, then I'm more than happy to do so.
And has she ever presented you with a receipt that you did not reimburse 50%?
No, ma'am, not that I can recall.
And school supplies, do you split those 50-50?
Yes, ma'am.
School clothes 50-50?
We buy clothes for our own households.
Okay. Now, in the underlying order, are you guys completely equal in your rights and duties in this underlying order as you're relating to your child?
Yes, ma'am, to the best of my understanding.
And there's nothing in this order that gives Miss Brown any superior rights over you?
No, ma'am, not that I'm aware of.
And is it your position that there has been no material and substantial change since the date of this order?
Yes, ma'am.
And your position is based on section 156.401 of the Texas Family Code that there would need to be a material and substantial change to modify this child support, correct?
That's correct.
Now, is it also your position that even if there were a material and substantial change, that you have a right to request child support from Miss Brown, the same as she would request it from you?
Yes, ma'am.
I mean, you have all the same rights and all the same possession and access, correct?
Correct.
And if you were requesting child support from Miss Brown, it would be based on minimum wage, correct?
Correct.
Now, if we offset your child support, which is calculated at $14.50.70 per month, if we offset that child support with a minimum wage child support and had Miss Brown pay 50% of the cost of insuring your child, the difference in the child support amount currently owed and what would be owed then would be $60. Is that correct?
Yes, ma'am.
$60.47.
Correct.
And you're requesting that this court deny the petition for the non-agreed child support review order and decline to modify the child support at this time?
Correct.
And you believe that's in your child's best interest?
Yes, ma'am, I do.
I pass the witness, Your Honor.
Redirect, Ms. Laskowski.
No questions, Your Honor.
Okay. I'm going to start with Ms. Brown now. You can speak to the things about what you believe about a material and substantial change that you wanted to have me consider before I make my ruling. Is there anything else you want to say about it? I understand that you felt like there was, but I didn't ever really hear your thinking on that. So this is your chance.
I was under the impression I was the primary custodian, and
Well, I've read through the decree a couple
Yeah,
of times because there's
okay.
other things I'm looking for, and I didn't find anything in the decree that designated that particular issue. In fact, the decree was pretty specific about geographical limitations. So
Yes, I understand.
I'm going to take the decree on face value regarding that issue. Ms. Laskowski, is there any other thing that you want to present in terms of argument as to why there's been a substantial change in circumstances? Or do you have any other evidence to present about income or anything else that would,
No, Your Honor.
okay.
I had one other thing.
Okay,
His living arrangements, he sold his house, and I mean, I guess his cost of living, he's living with somebody else. He's not actually, he doesn't have like a mortgage anymore for the house that he was living in.
well, that's a limiting factor, but I don't think that really doesn't speak to change of circumstances. I mean, people find different living arrangements that changes how they can handle their money. I'm not going to give that the level.
Okay, it
Here's
was
the
just an
problem.
issue on the decree for me for some
Yeah,
reason.
I understand. But the decree's there and it stands on its own merit. We're here to see if it's proper to modify it.
Yes,
I
sir.
really, I'm sorry, Ms. Parker. I kind of have my idea where I'm going, but I'll give you the chance to argue your side of it before I do.
I mean, just to sum up, Your Honor, I mean, our position is just obviously that we don't believe there's been any material and substantial change that would warrant a change of the modification of this. The parties agreed to an amount that differed from what guidelines would be. And that guideline child support offset was based on what each of them would pay if they were paying child support for the child before the court. And based on that offset, the amount ended up being $1,000 per month. And even if you take that same logic and you do the offset, it still isn't changing. I do believe that that Ms. Brown will earn in excess of the minimum wage that we're calculating that offset on as a server, even though we at this point don't have any pay stubs to show that. But our position is that there isn't a material substantial change that would be required to necessitate any sort of change. But that even if the court were to find that there's a material and substantial change, that if you calculate the child support, it still doesn't end up being at least $100 a month. Yeah. And, that's our position. There's just not a basis to change the child support.
Yeah. The problem I have with this divorce decree, and I've seen that a lot over the years, and the AG is very careful to speak to deviations, and this decree really doesn't clear it up. And I believe there could be an argument for presumption that it was guideline support based on the fact that it's silent on that issue. I'm going to agree with you that all the evidence indicates that even if you're going to use increased income as a basis for a changed circumstance, you haven't reached the threshold. So I'm going to deny the modification. You can, if you'll get that denial to me right away, Ms. Laskowski, I can trigger the 3 days. If Ms. Parker wishes to appeal this decision, she'll have to have or if your office wants to appeal the decision, you'll have to have your appeal in by Monday. But I'm denying the modification. I'm finding that it did not reach the threshold for a material and substantial change that would warrant a modification of the decree.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. And again, Ms. Parker, if you wish to appeal this back to the court, you have 3 working days to file for a de novo, and you must do that by Monday.
I understand, Your Honor. Thank you so much. Are we excused for that to be circulated by email, or should we wait around to get
it doesn't require signatures on just a simple denial. And I think my problem with these Zoom hearings, it has been ever since we started doing them, is making sure the parties knew the specific date of signing, so it triggered the actual. I mean, I have had times where people would file an appeals before I actually sign the order. So let's get the order signed.
I understand your order, and we don't plan to appeal, but I understand that. But thank you.
Ms. Parker may want to appeal, so you definitely need to get that order to me so that
Sure, I think you meant Ms. Brown, Your Honor.
Okay, I'm sorry, Ms. Brown.
Yeah,
Ms. Parker is the attorney. Ms. Brown may want to appeal, and I certainly want to give her that opportunity. So try to get me this order denying this modification today, so she'll have something.
I am working on getting that drafted right now. So if the parties want to return
Yeah,
to.
go ahead and circulate it so everybody knows.
Yeah,
what
if the
we're
parties
doing.
want to return to those breakout rooms, I can probably get that circulated to them very quickly.
Okay, all right, thank you.
Thank you very much.
And Ms.
Thank
Parker,
you.
let me close the record. Okay, we're off the record now. Your other case, Ms. Parker, I think that's going to be passed. The other lawyer in that case came in and
Okay, we do already have a private, I mean, we have a private case pending, which we had pending before this other case. And we do already have temporary orders, and the AG did sign off on our temporary orders. So I think it was probably set by mistake or just hadn't.
okay. All right. Well, I just wanted to make sure knew you were free to go as soon as we.
Perfect. I was going to check on that. Thank you so much.
Thank you.
Thank you.
Are you sending us back to the breakout rooms?
Yeah.
Because
I have to get, is Miss Laskowski, can you put them back in the breakout rooms as co-host?
At the bottom of your, well, it's probably at the bottom, somewhere in the frame of your screen, there's a square that's 4 squares, look like a window pane. If you'll click that, that'll take you back to your previous breakout rooms.
breakout room 4. Okay. All right. Perfect. Thank you.
Okay, Ms. Brown, did you understand that?
Yes.
Yes.
Ms. Brown, okay, y'all go on back into your various rooms and we'll circulate the order I've made, so Ms. Brown will know what her appeal rights are. All right. Now let me go find Ms.